All right, today we are digging into a brand new and frankly critical risk that's hitting corporate leaders. This is all based on a really insightful report from Virtualization Options LLC, and we're talking about something huge: personal liability when your company's AI goes wrong. The game has totally changed for the C-suite and the boardroom.
So, just to set the stage, let's talk about scale. We're seeing that somewhere between 50 and 75% of companies are already using AI in their operations. This isn't some far-off trend, it's happening right now, and it's fundamentally changing how business is done.
And with this massive, rapid adoption comes a huge shift in legal liability. This is a risk that's no longer just stuck in the server room with the IT team. Note, it has marched right into the boardroom, and it's affecting executives and directors in a very, very personal way.
And here's the bottom line. The days of just handing off AI to the tech department and washing your hands of it, they're over, gone. We are now in a world where if an AI system fails, it's not just a corporate problem. The personal assets of directors are now squarely on the line.
So, how did we even get here? To really get a handle on this new reality, we have to look at how the whole legal and regulatory landscape has just been completely upended, putting boards directly under the microscope.
What's so fascinating here is you've got this perfect storm of forces all converging at once. First, those age-old fiduciary duties, the duty of care and loyalty, they now clearly include overseeing AI. Second, courts are basically laughing off the old "I'm not a tech person" excuse. And third, you have regulators like the SEC flat out saying that having AI competence on your board is no longer optional.
And let's be clear, this isn't just theory or something to worry about in the future. We are already seeing a whole new wave of legal attacks that are specifically designed to target directors personally for failures in AI governance. This was a real watershed moment. We saw shareholders file what's called a derivative lawsuit. That's where they sue the board on behalf of the company. They claimed the board completely dropped the ball by not properly overseeing an AI credit model. This case set a massive precedent. Fail to govern your AI and you could be sued by your own shareholders.
And here's another huge threat, something people are calling AI washing. It's simple. A company hypes up its AI capabilities to juice the stock price. Well, regulators are now cracking down hard. And when they do, they're not just finding the company. They are holding the individual directors who signed off on those misleading public statements personally accountable.
This table does a great job of boiling it all down to the three main ways boards are getting hit. You've got those shareholder derivative suits for bad governance, securities fraud for lying to investors, and even product liability. Imagine an AI billing system going haywire. That can cause real harm and trigger massive regulatory fines.
Now, right about now, you're probably thinking, okay, but wait, that's what directors and officers insurance is for, right? Well, this is where the risk gets incredibly personal and, honestly, pretty scary. That safety net you thought you had, it might be full of holes.
The hard reality is this. The traditional D&O insurance that has been the bedrock of protection for board members for decades is becoming pretty much useless when it comes to AI. Insurers are sprinting away from this new, unpredictable kind of risk. And here's why. Insurance companies are sticking in this incredibly broad exclusion language for any claim that's even remotely arising out of AI use. They're denying claims if your third-party vendor's AI messes up. They're using old cyber policies to deny new AI risks. What this means for you is you could be left paying for your own multi-million-dollar legal defense right out of your own pocket.
And look, don't just take my word for it. This analysis from the Harvard Journal of Law and Technology just lays out the brutal truth. When an AI lawsuit hits, you could find yourself completely on your own, with your personal wealth hanging in the balance.
Okay, so the risks are crystal clear, and the insurance safety net is basically gone. Let's pivot from the problem to the solution. Because if you can't rely on insurance, you have to build your own defense, and that starts with rock-solid governance.
But that brings us to the million-dollar question, doesn't it? A lot of these advanced AI systems are essentially black boxes. They spit out answers, but you can't always see the reasoning. So how on earth can a director do their job and oversee a system they can't fully understand?
Well, the answer is a principle called explainable AI. As a director, you don't need to be a math genius, but you absolutely do need to be able to understand what the AI does, the risks it creates, and what might make it fail. The new rule for governance is simple. If management can't explain it in plain English, you shouldn't be deploying it for critical decisions. Period.
Okay, let's get super practical now. We're going to walk through a real, actionable plan for what your board can do, literally starting Monday morning, to build a governance framework that can actually stand up in court. Following these 5 steps is how you build your defense. It's about creating dedicated committees, clearly writing down who's responsible for what in the charters, setting up regular reviews, and, this is the most important part, documenting absolutely everything. That documentation, that paper trail, is what proves you did your job when a lawsuit comes knocking.
And here's a crucial point. You can't manage AI risk in a vacuum. It has to be woven into the very fabric of your company's existing enterprise risk management. That means looking at new cyber threats unique to AI, tracking this incredibly complex web of new regulations, and doing some serious due diligence on your AI vendors.
So when you step back and look at this whole changing landscape, what's the ultimate takeaway? What does all this really mean for accountability in the C-suite going forward?
Ultimately, it means that proactive governance isn't just a best practice anymore. It's not something you do to be innovative. It has become a core, fundamental part of a director's legal duty of care. It is a legal must-do.
And this really is the question that every single director needs to be asking themselves right now. Are we prepared or are we exposed? Because the time to act was yesterday. Every day that goes by without strong, documented AI governance is just another day you're piling on more and more personal liability risk.
And finally, of course, a necessary disclaimer. This is for informational purposes only. It is not legal advice. If you're concerned about this, and you probably should be, we highly recommend you seek guidance from your personal attorney or corporate counsel, someone who's familiar with all the laws and trends in your specific jurisdiction.